So as a DPO, this is very important for you to have a roadmap of what is expected from you, right? And whenever you start building a data privacy program, there are certain mandatory activities to be conducted. There is a sequence of doing certain activities, and there are certain activities which you will be doing on a parallel note. So these nuances you understand, and they are very important. So to transition a program, maybe at a conceptual stage it may all look the same, but each of them have a criticality of when to be performed and how to be performed, right? And it's actually a program which is pretty new to many of the Indian firms, because data privacy programs are not being existent. Many organizations are trying to figure out how to manage this, and with the DPDP Act knocking the doors, expected to have the rule enforcement could be in this summer, and most companies will need to have an answer to the requirements, right? So that's why the CIPM program is very much aligned, where you understand how to operationalize a data privacy program, right? And part of this, there are certain activity which you see on the screen, and I'm going to align this to your CIPM course in terms of how do you actually do it with the CIPM course. Usually the CIPM course is divided into two parts. One is your governance and second is your operations. So the first two steps is typically part of your governance, right? And when we say governance, it's important to understand your obligation as an organization, as well as the business landscape where you're operating, what type of data you handle, and what are the different nitty-gritties that exist by the nature of business you handle, right? So these important obligations to be identified, and your role as a controller, your role as a processor, right, and the vendor ecosystem you're operating, all these are some of the important information for you to understand, because these information will have a lot of impact on your subsequent design of a program. So starting with your third step on the sequence, that is where you move into assess zone, right? And part of the assessment, there are various types of assessment as an organization you may conduct. It could be a simple gap assessment with the impending law, or it could be a case of your in terms of a data discovery assessment. You may also do assessments which are mandated by the law, such as DPIA and transfer impact assessment if you are operating in GDPR. And there are various types of assessment that usually happen, correct? So part of these assessments, the intention is to identify the various types of gaps and various types of lack of controls which you need to implement as part of your implementation stage. So the next step is your protect stage. So your second set of events, they might run in a parallel node. They are not exactly sequence. For example, the next step is your privacy framework, right? So in the part of assess phase, you will also try to discover the data, and here you are trying to formulate those data into a structured process called as personal data inventory or records of processing activity, right? And you'll also be developing your privacy framework and then moving towards implementing your controls part of it. So then there are certain operational activities which are routine, which are triggered by various assessments. So the first step of gap assessment is mainly from an organization standpoint, how much we are ready. And from the CIPM course, these assessments are all clubbed together, right? But as an organization, it's not an one-time activity. We will be doing them as a routine activity as well. And that's where you have various assessments. I'll just give you the hint of it. And manage the data subject rights. These are all the response in terms of your data subject response, your breach management, and there's your continuous improvement, which is mainly an outcome of your sustained phase, where you understand your continuous improvement requirements and then keep improving over a period of time. All right. So whatever you looked at is typically what a DPO has to understand. A privacy program manager has to have these sort of plans in their mind as a roadmap for the first 2 to 3 years, because these activities, many people think that data privacy is like a checklist exercise, and unfortunately that is what many people believe, that once we have a privacy policy in place, put it in the website, and our privacy compliance has been taken care. But unfortunately that is not the truth, and it's not possible for you to achieve any sort of compliance with the checklist activity. All right. And this is where you need to understand, if you build a information security program in your organization, it would have not been done overnight, correct? It would have definitely taken an organization to mature over 3 to 4 years minimum. This is going to be applicable even for data privacy. So please don't expect data privacy to attain maturity in a span of 3 months, 6 months, just because you implemented a tool, just because you started, you brought a consulting company into the picture, and they might have promised that we will fix everything in 2 months, 3 months. That is actually not possible. Of course you can fix it in terms of a one time effort, but you still need to sustain those efforts to ensure your compliance, and most of the case you may not be able to achieve a compliance state within a span of 3 months, especially for your medium to large size organization. So this is something which you need to understand. So you, what you see on the screen are the four life cycle stages of personal data, as well as aligned with the your CIPM course: assess, protect, sustain, and respond. And so this is going to cut across the personal data life cycle as well, which is create, store, use, share, archive, and destroy. Right. So you need to understand that personal data, right from collection till it's disposed, every single action you perform on the door, on the on the particular data, you have responsibility called out in the law, right? And it is based on your category. Maybe you're a significant data fiduciary, or you are a controller, or a independent controller. There are a lot of nuances which you need to be aware of in terms of knowing what exactly you are obligated to perform on that particular data. All right. So why I brought this particular slide to show you, like, why is it important part of the assess stage to understand the obligations as an organization. So if you're operating within one country, your life is much easier. The reason is there is only one law which you need to cater with. But even in that case, there could be many regional laws, right? Regional laws, I mean, in terms of regulatory requirement. For instance, if you're working in healthcare sector, right, and you could be working in financial sector, banking sector, there could be a number of regulators. It is definitely expected, regulators like your SEBI, your RBI, your TRI, all of them are going to bring some additional obligation on top of the data privacy law, right? So, which is clearly an indicator that you need to not only fulfill the data privacy law, but your regulatory obligation are going to be much more specific, and that's going to be even more stringent, right? And this is the reason, and the scenario becomes much more complex if you are operating across multiple countries in the world, right? And this makes a very important estimation of how much effort is required towards your compliance journey. And there are too many laws in one country means, then imagine there are too many laws for you to cater across different countries. The effort is definitely going to double. As we speak, we can confidently say there are close to 95 to 100 data privacy laws are in the making, or almost in a state of enforcement or awaiting enforcement, right? So that's a good news for many consulting companies, but not so good news for many companies which are acting as a processor, right? So as a processor, if you are into software as a service or cloud service provider or any of these IT services company, trust me, you have a lot of work to do, right? And that means you need to be compliant under various provisions, correct? So this is the reason I keep saying that please don't expect data privacy to be a checkbox exercise. So one important strategy that you will learn part of the CIPM course is We in consulting language we used to call this as unified control framework, or in simple words we will try to identify the common threads between the various data privacy laws, right? And this can reduce your efforts drastically from complying with maybe 5 or 10 different data privacy law, and looking at a common baseline across various law and arriving at what are the ones which is sort of commonalities between the various laws that helps you to limit your efforts as well, right? Just to showcase this as a strategy. And sometimes we often pick the most stringent law as a reference, so that if you fulfill that particular stringent law, then in most of the cases, right, the other regulations could be satisfied. But please don't make a mistake here. There are laws which certain with unique touch points as well. For instance, let's say in Brazil, every company needs to have a DPO appointed. Similarly, in India, we have consent manager, which is very unique to Indian law, right? And for example, in GDPR, we have right to restriction, right, which you will not find in many data privacy laws as well. So the idea here is, although there can be common aspects between data privacy laws, but there could be a high chance of standalone or standout obligations, right, which you need to be tackling them, right? So this is one thing which you will definitely learn from CIPM. And as we do the assess part, the most important outcome could be your gap assessment report and your records of processing activity, right? So let's say if you have been following the Indian law closely, you would have never seen a direct requirement that such as your personal data inventory or a records of processing activity. But does it sounds to you that if I tell you there is no possibility to run a data privacy program without identification of your personal data and having an inventory about it? This is the foundation. Without this foundation, it becomes very, very difficult for you to fulfill any other obligation. Maybe there is a data subject rights as an example, or doing a data protection impact assessment, right? Or even for the matter of looking into your breach impact assessment. Unfortunately, there is an incident of a data breach, right? So this is the reason I would say there are certain hidden obligations, right? Although the Indian law is not directly calling you to do a personal data inventory, correct? But it's impossible for you to drive a program without a personal data inventory or records of processing activity, correct? So this is one thing. And the elements of a records of processing activity again will vary from one country to another country. Let's take an example. In GDPR, it will have specific obligation for a controller, specific obligation for a processor. Now, in Indian law, there is no obligations on the processor at all, correct? And this is where it becomes very interesting and very tricky for you to maintain these kind of inventories for a multinational company, right? And you need to have this visibility. It's very important for you to respond to various other obligations. And without such personal data inventory, it becomes very, very difficult for you to fulfill any subsequent obligation that are linked in a privacy program, right? So in part of assess chapter, you will understand that why you need to do this, how can you do this. There can be different approaches. One approach could be in terms of doing a manual approach, where you will discover the data with your interviews with various teams, and probably you can also do it in an automated approach using data discovery tool. So the data discovery tools will also be working in a very similar way of how your antivirus or any other companies will typically work, in terms of crawling various types of data. And it will be able to, now they deploy your AI/ML as well, in terms of categorizing the data as per the various obligations, right? So this also needs a very handhold approach, because out of the box any tool may not be able to answer all your questions in one go. There has to be fine tuning. There has to be definitely a few reconciliation which needs to be performed, right? So these are the nuances which you will definitely discuss during the sessions. Now, part of the assessments, one important assessment is your DPIA. One of the classical topics within the data privacy course. The reason is often it's very confused between the people in terms of what is the difference between a DPIA versus privacy impact assessment, and people believe there is definitely a difference, and it could be a possibility of a confused term. There is a lot of things to discuss in this. Probably I will keep this as a suspense for you to join my sessions to give you the answer. But to give a high level answer for the people joining me for the first time, definitely don't focus on an approach where you differentiate it yourself. Try to follow the law. That's the most important answer which I can tell you. Follow the law of the land. That guides you in terms of how to handle these kind of assessments, right? That's the most important part. Now, whenever you're doing a DPIA, there is a clear intent of what you are trying to achieve. The intent is to avoid high risk processing activity, right, which cause a very big impact on the data subject, correct? And this is where you are trying to do this assessment, and many people think again this like a checkbox exercise where you do it once, right? But this is not a one time activity. This is started at a very early phase of the project, and you will still continue to do it along the case of your deployment, and still trying to assess if any of the parameters have changed. All right. So this is important, that you need to understand the nuances of how you conduct a DPIA. And there are laws like GDPR which has some very important prerequisite. For example, reporting back to the supervisory authority. Maybe the Indian law could follow the shoes of the GDPR, where the Indian Data Protection Board can give some guidelines on the same lines, right? So then you need to understand when will you be obligated to do such a step, right? And you also need to understand like why this particular discussion with the authority needs to be done, and if at all it happens, then what could be the outcome of it. There is definitely a possibility where the authority can even say you should not proceed with this activity, correct? So these are some of the nuances which you need to understand. And as you see on the screen, these are some of the uh, examples of your high risk processing activity which is called out in the GDPR. All right. So this could also be varying from one country to another country. Please don't follow GDPR as the ultimate reference for each and every nuances. Why I'm saying this? Of course, GDP has inspired many laws, but some regulatory authority could differentiate this. They might arrive at some other examples, or maybe they are extrapolating some more examples of your high risk activities as well. So always follow what is being stated on the your law of the land. All right. Another example is your transfer impact assessment. Although it is now too early in the Indian law, but this is something which is very well established in many other laws as well. For example, if in GDPR, if the data is going out of the country, you need to perform a transfer impact assessment, right? So again, there are two important elements here. One, whenever the data is coming inside the organization, right, no country is gonna keep any restrictions on that. But the moment the data goes out, that is when these obligation gets triggered. So what is going to be followed in India? It's going to be a case of a simple blacklisting approach, right? So in India they say that except these blacklisted country you may transfer the data, right? But in case of GDPR, they have a very comprehensive approach, right? And this is where you need to understand these nuances, right? So transfer impact assessment, the way the steps involved here, and in case of transfer impact assessment, it's even unique or peculiar compared to many other assessments. And the difference here is, in many of these assessments, you will be evaluating the organization, right? Most of the assessments are evaluating the processing activity or the organization which is involved in this activity. Am I right? But in transfer impact assessment, the case is slightly different. It is going to be looking into the laws where the importer of the data is present, right? There are certain interesting elements which we'll be discussing part of your transfer impact assessment. So once your assess stage is done, you need to build your protection. So for that, the gaps whichever is identified part of various assessments, could be a gap assessment, could be part of your DPIA, could be any of these assessments, right? There, trust me, there are so many assessments that can confuse you. There is a threshold assessment, or people can call it screening question. Then there is a privacy impact assessment, data protection impact assessment, legitimate interest assessment, transfer impact assessment. There are so many assessments, right? But each of them do have a purpose which is being called out in various laws, right? And in terms of your protection phase, right? So protection is about how you are going to fix your problem. See, the problems can be basically fixed in terms of creating a privacy framework. A framework could be your policies, procedures, right? And in terms of, from the privacy framework, you can then develop your controls and implement it, right? So I'm not going to go into details of all these things, but one thing which you can relate to here is your privacy by design. Again, a lot of people confuse, Jay. I have good understanding of data privacy. I work in my organization on data privacy, but unfortunately, I still can't answer except the theoretical perspective of what is privacy by design. Like, what exactly is a straightforward answers of what are the 10 things which I need to do part of privacy by design, right? It is quite challenging because many of them are interrelated, and many a case these principles are qualitative and nature, right? So I can give you a very simple formula or simple methodology. In any case, if there are principles, like you have GDPR principles or fair information privacy practices, FIP or FIPP, whatever you call, if you fulfill most of these principles within your organization, trust me, most of your privacy by design is taken care. Okay. So privacy by design is automatically doing the things in the right way from the beginning of your development activities or your operation activity, correct? And that is what your even your privacy principles are requiring you to do. It's just that you need to have that understanding of how to do it. That you will definitely gain with the understanding of reading and going through a guided approach. Okay. So once you have developed your framework, there are various types of controls which we will implement. Again, another key area of confusion is between what is the difference between information security and data privacy. Many people believe data privacy could be a sub-function of information security. This is what is sort of understood in many people, maybe working from an information security background, or people traditionally think, okay, since data privacy program is run by the information security team, this could be the subset. But ideally speaking, this is not the case. And the reason for that is we have certain elements of data privacy which is very, very specific only to data privacy principle discipline. The reason for that is, let's take a very simple question. Okay, the simple question could be, in information security, we seldom ask this question, why are we collecting this data? Do we have the right lawful basis to collect the data? Even if we have a lawful basis, are we collecting only the minimum data and relevant data that is required? These questions are never ever asked in information security. Am I right? So information security starts when the data comes within the organization. correct? That is when the entire journey starts. You identify the data, classify the data, protect the data with relevant controls, correct? That is something we do over and above in data privacy, where we even question why are you collecting this data, part of your privacy and data protection. Now, that is where you need to understand that privacy is originating from a law, it's a legal requirement. So, you need to handle it with caution. Of course, for achieving your data privacy objectives or compliance of the law, it is impossible for you to do it without information security support. Many of the personal data protection support, or in terms of protecting personal data, it's definitely dependent on your information security team, right? So that being said, you cannot say both of them are completely like you cannot say data privacy is a subset of information security for sure. All right, so that's something you need to understand. Each of them have a specific role, and there is a good amount of interplay between these topics, and you will need to understand how do you work together within the organization to solve this. All right, so there are certain important elements which you will learn for the first time, which is your process oriented strategies and data oriented strategies. So these strategies help the organization to fix or implement the right set of controls, right? These design strategies definitely help your architecture, okay, in terms of right from a very early stage. How do you actually build the right set of controls? So this perfectly coincides even with your privacy by design as well. All right, so you need to understand these various approaches if you are to become a successful DPO. For becoming a data privacy manager, definitely you need to learn these nuances. This is something which will be introduced part of your CIPM course. And this is all about your protect stage. Then obviously we will move on to the next stage, which is sustain. Typically in sustain, two major activities, which is your training and awareness. I'm not going to touch on that. And then we will have in terms of your metric analysis, metric, your internal audit, and this is what we do part of the sustain phase. So you have built a program, you have implemented controls to fix the gaps, but now the problem statement is, are we able to move in the same trajectory that we planned, right? Do we lack in terms of any control implementation? Are we able to achieve what we sort of planned, right? So metrics are definitely very important enabler for the top management to see how the privacy program is performing to the expectation, right? There are various metrics which you will understand, and then you will also be looking into the various types of audit and related how do they help an organization to sort of fulfill the intent of sustaining a privacy program. Okay, so the last component will be the response phase. So part of the response phase, right? And we typically have two important activities. One is your data subject response, and second is your breach notification response. So breach notification response is a very, very important activity. See, for doing a breach notification, the what you see on the screen, there is a 72 hours, right? There is a 72 hours notification timeline given in the GDPR. That's going to be the same is what we understand in the Indian law as well. And then you also have another important timeline, which is the moment you see a high risk, you need to do immediate notification to the data subject in GDPR. But in Indian law, there is no graded approach, which has been called out right now in the draft law, which is obviously expected to be rectified. Hopefully, we will see a change there, and that is something which will definitely answer us in terms of how do we handle a high risk situation, right? And whenever you respond to the data subject and whenever you respond to the authorities, there are certain information to be provided as well. That's even more important, right? So for doing that, there is an important activity we do called as breach impact assessment. Again, this goes back in terms of the importance of your personal data inventory, right? So without having a visibility of what data you collect, what data you handle, it becomes very impossible for you to do a breach impact assessment within 72 hours. The reason is you are mandated to send a notification to all your data subjects who have been breached. At that particular time, you are trying to discover who's your data subject, where all the information has been accessed. This is where it can go terribly wrong, right? So that is why I keep saying your data discovery and your data mapping is a very, very important activity. It is almost like a backbone for the entire data privacy program. Okay. So responding to a data breach, this is a seven-step approach where typically you need to evaluate various factors, right? Responding to a data breach is also not like the authorities are not like your phone a friend, correct? Obviously, they will expect you to answer them in terms of few important questions, especially how many people are impacted, what kind of data is being impacted, and what kind of measures have you taken, what is the root cause of that. So all these important questions are going to be taken, asked as well. And sometimes you need to understand, if you are from an information security background, you will probably know that it is not possible for you to have the answers always upfront, isn't it? So then in those cases you might be doing a staggered approach where you notify what you have and then probably line up in terms of providing additional information to the authorities as well, right? So this is where you need experience to know how do you interpret the obligations of the law and how do you actually implement and advise your top management in these kind of critical situation. This is where data privacy manager has a very, very important role. And trust me, you might thinking, Jay, why are you too much worried about a data breach as of now? Trust me, many of the companies are facing this as we speak, and the reason for that is very, very simple, and that is because you traditionally ignore personal data breach thinking it is just the contact details, it is available everywhere, and probably people are not paying attention saying that the data was not critical. But the definition of personal data is very, very clear. Okay. So you need to be aware of those nuances, and personal data breach attract a very, very hefty penalty, right? And maybe you are lucky if you have sort of get away without a penalty during these times. But once the data protection board is convened, and probably you will see the authorities will be ringing a bell with the penalties. The intention is to sort of set a tone, right, for everyone to follow. This happened with GDPR as well. Those hefty penalties which we saw with Amazon, with Flipkart, sorry, not Flipkart, your Facebook and Twitter, all these companies face these penalties, and that is basically to sort of send a message to the entire ecosystem. It is expected in India as well. All right. Uh, Apart from this, the data subject rights response. One area which I keep telling to all my participants who would join my training is that in information security, maybe 10 years before, no one would have thought the information security domain is this vast as we see today. Like you have multiple disciplines within information security. You have a, SOC team, security operations center team. You have a identity access management team. You have a GRC team. You have multiple teams with multiple disciplines and expertise. Correct. And one such area will happen within the data privacy, will be in terms of data subject rights management, your consent management, right, and your assessments. So these three areas will definitely pan out into a very, very big and important obligations, and very difficult for you to comply with them that easily as well. And the reason for this, take a simple example in India. The amount of customer data a bank, an insurance company, or any B2C sector, they have a huge volume of data subjects, right? And trust me, if it becomes a sort of data privacy hacktivism and everyone starts raising a right to access, do you have the bandwidth to handle such request? That's going to be a very important question to be asked to your management. Do you have the resources? Resources is not only always people. Do you have the tools? Do you have the process in place? Right? So these are some of the most important elements which you need to bring the top management to understand why this program is important, right? So this is what the course helps you to speak the right language, and once you get the opportunity, implement it in the right way. Okay. And again, interesting element is you see the various types of uh, data subject rights will also vary from one data privacy law to another data privacy law, right? So in India, you have only four data subject rights. In GDPR, you have around eight. And that is again a common thing which you need to be sort of aware of. And you need to, but there are basic rights like right to access, right to delete, right to rectification. So these are rights which will be common in most of the data privacy law without a doubt, correct? So even to fulfill that in terms of your right to access or right to deletion or right to modification, you will definitely need a huge investment in terms of the resources. All right. So it's not a easy task to do. All right.